Good day everyone, and welcome to another episode in our What If series, where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. My name is Ross Simon from Maserumule Corporate Employment Law, and in today's episode we're unpacking the question, what if a bargaining council commissioner awards more compensation than the employee asked for? The 2025 Labour Court ruling in Malas Proprietary Limited versus Stapelberg is what we'll be discussing today. This case raises a key issue in unfair dismissal disputes. If an employee makes a clear and specific request for compensation, can a commissioner lawfully go beyond that? Let's take a look at what happened. Mr. Hussein was employed by Malas as a product manager. He was dismissed in October 2021 after 2 incidents involving pricing errors. He was charged with gross negligence and dismissed. Mr. Hussein referred an unfair dismissal dispute to the Motor Industry Bargaining Council. Crucially, Mr. Hussein was legally represented and did not ask for reinstatement. Instead, he asked for 3 months' salary as compensation. The Commissioner found the dismissal to be substantively unfair. However, instead of awarding the 3 months compensation requested, he increased the amount to 4 months, stating that it was more appropriate. Then, without any further reasoning, he awarded an amount equivalent to 5 months' salary. There was no justification, no supporting evidence, and no explanation as to why the award exceeded the request made by Mr. Hussein. The employer challenged the award at the Labour Court. The employer did not challenge the finding of unfair dismissal, but the excessive compensation. The court acknowledged that commissioners have a broad discretion to determine compensation up to 12 months remuneration under Section 194, subsection 1 of the Labour Relations Act. But that discretion must be exercised reasonably and supported by valid reasoning. In this case, the court found that the Commissioner had not done so. Here's what the court had to say. Mr. Hussein had specifically requested 3 months' salary as compensation. He was legally represented when that request was made. It was unreasonable for the Commissioner not to ask why Mr. Hussein's legal representative determined that 3 months was fair and just. A reasonable commissioner, considering a higher amount, would have asked whether Mr. Hussein had found another job and what the company could afford. The commissioner made the award despite acknowledging that Mr. Hussein's relatively short period of service and failed to consider other evidence, including that Mr. Hussein was partly responsible for at least one of the incidents. He also failed to compare the award with amounts granted in similar cases. As a result, the Labour Court found the award to be unreasonable and reduced it to the originally requested amount, 3 months' salary. Let's take a moment to reflect on the lessons here. For employers, when an employee clearly requests a specific amount of compensation, especially when legally represented, a commissioner must have clear, reasoned justification for exceeding it. If not, there are reliable grounds for review. Remember, compensation must be fair, but also evidence-based and defensible. For employees, when you ask for compensation, especially through your legal team, that request is likely to be treated as your final position. That brings us to the end of this week's episode. Thank you for joining us. We hope you have found our discussion informative. As always, if you have any questions or comments, we'd love to hear from you. You can contact us on social media, or you can email me directly at ross@massconsulting.co.za. Until next time, take care and goodbye.